It is based on that I hereby make an order that because of the unruly behavior of defendants, his aggressiveness and violent nature, I hereby make an order that the judgment and other proceedings proceed in his absence. I take my judgment. The defendant was arraigned before this court on 7-count charge, which reads thus. Count 1. That you, Nnamdi Kanu, male, adult of Afaranuku Ibeku in Umo North Local Government Area of Abia State, sometimes in 2021, being a member and the leader of Indigenous People of Biafra, IPOB, a pro-tribe organization, did commit an act in furtherance of acts of terrorism against the Federal Republic of Nigeria and the people of Nigeria by making the broadcast received and heard in Nigeria within the jurisdiction of this court, with intent to intimidate the population, and you threatened that people will die, the whole world will stand still, and you thereby committed an offense punishable under Section 1, Sub 2B of the Terrorism Prevention Amendment Act 2013. Count 2. That you, Nnamdi Kanu, male, adult of Afaranuku Ibeku in Umo North Local Government Area of Abia State, sometimes in 2021, did commit an act in furtherance of an act of terrorism against the Federal Republic of Nigeria and the people of Nigeria, made a broadcast received and heard in Nigeria within the jurisdiction of this honorable court with intent to intimidate the population. You issue a deadly threat that anyone who flouted your sit at home order shall write his or her will. As a result, banks, schools, markets, shopping malls, fuel stations, domiciled in the eastern states of Nigeria were not open for businesses. Citizens and vehicular movements in the eastern states of Nigeria were grounded within the jurisdiction of this honorable court, and you thereby committed an offense punishable under Section 1, Sub 2B of the Terrorism Prevention Amendment Act 2013. Count 3. That you, Nnamdi Kanu, male adults of Afaraku Ibeku, Umo, committed an offense punishable under Section 1(2)H of the Terrorism Prevention Amendment Act 2013. Count 5. That you, Nnamdi Kanu, male adults of Afaranuku Ibeku Umo North Local Government Area of Abia State on date between 20 guys of the public in Nigeria to hunt and kill family of Nigeria security personnel, and that you thereby committed an offense punishable under Section 1(2)H of the Terrorism Prevention Act 2013. Count 6. That you, Nnamdi Kanu, male adults of Afaranuku Ibeku in Umo North Local Government Area of Abia State, dates between 2018 and 2021 made the broadcast received and had in Nigeria within jurisdiction of this court in furtherance of an act of terrorism against the Federal Republic of Nigeria and the people of Nigeria, in which you directed members of the indigenous people of Biafra, IPOB, a proscribed organization, to manufacture bombs, and you thereby committed an offence punishable under Section 1(2)(f) of the Terrorism Prevention Amendment Act 2013. Count 7. That's you, Nnamdi Kanu, male, adult of Afaranuku Ibeku in Umuahia North Local Government Area of Abia State, on date between the month of March and April 2015, imported into Nigeria and kept in Uguluzo in Ihiala Local Government Area of Anambra State. Within the jurisdiction of this court, a radio transmitter known as Tram 50L concealed in a container of used household items, which you declare as used household item, and you thereby committed an offence contrary to Section 47(2)(a) of the Criminal Code, Cap C45, Laws of the Federation of Nigeria 2004. In discharging its body of proof, the prosecution called 5 witnesses as follows. 1. Mr. AAA as PW1, Mr. BBB as PW2, Mr. CCC as PW3, Mr. DDD as PW4, Mr. EEE as PW5. The prosecution also tendered the following, which were admitted in evidence by these courts. 1. A document titled Items Recovered from Nnamdi Kanu of Radio Biafra at Golden Oak Cliff Hotel, located at number 42/44 Airport Road, Lagos, on the 15th day of October 2015, was admitted and marked as Exhibits PWA. 2. This titled Interview with Nnamdi Kanu and a Certificate of Compliance filed on the 28th day of April 2025 were admitted and marked as Exhibit PWB and PWB2 respectively. 3. The statement of defendants dated 15th day of October 2015 was admitted and marked as Exhibit PWC. 4. A process titled A List of Items of Nnamdi Kanu filed on the 19th day of March 2024 was admitted and marked as Exhibit PWD. 5. 4 bags as identified by PW1, Mr. AAA, were admitted and marked as Exhibits E-Bag A to E-Bag D respectively. 6. Items in Exhibit E-Bag A as identified by PWA were admitted and marked as Exhibit E-Bag A1 to E-Bag A13 respectively. 7. Items from Exhibit E-Bag B were admitted and marked as E-Bag B1 to E-Bag B32 respectively. 8. 10 items from Exhibit E-Bag C, Exhibit E-Bag C1 to Exhibit E-Bag C10 respectively. 9. Contents of Exhibit E-Bag D were admitted and marked as Exhibit E-Bag D1 to Exhibit E-Bag D17 respectively. 10. A letter dated 10th day of June 2021 from the Attorney General of the Federation and Minister for Justice, addressed to the Director General, Department of State Service, was admitted and same was marked as Exhibit PWF. 11. The statement of the defendant Nnamdi Kanu dated 17th day of July 2021 was admitted as Exhibit PWG. 12. A device to it, flash drive, black and red in color, and a certificate of compliance were admitted and marked as Exhibit PWH and PWH1 respectively. 13. A disc in respect to the statement of the defendant taken on the 17th July 2021 and certificate of compliance thereto were admitted and marked as Exhibit PW1 and PWI and PWI1 respectively. 14. Federal Republic of Nigeria of Official Gazette number 99 in volume 104, dated 20th day of September 2017, titled Terrorism Prevention Order 2017, was admitted and marked as Exhibit PWG. A document to its medical report titled Late Ahmed Gula, Hospital number 013931, dated 18th July 2021, was admitted and marked as Exhibit PWK. 16. A certified true copy of the judgment in HIN/FR/2021 between Nnamdi Kanu versus Federal Republic of Nigeria and 7 others, delivered on the 19th day of January 2022, was admitted and marked as Exhibit PWL. 17. A certified true copy of judgment in FAC/UF/CS/30/2022 delivered on 26 October 2022 between Nnamdi Kanu versus Federal Republic of Nigeria and 2 others, was admitted and marked as Exhibit PWF. 18. A certified true copy of the judgment in suit number E/2023 between Mazi Nnamdi Kanu applying for himself and on behalf of members of indigenous people of Biafra IPOB versus Federal Republic of Nigeria and 4 others, delivered on the 26th day of October 2023, was admitted and marked as Exhibit PWN. 19. A document titled Lagos State Judicial Panel of Inquiries on Restitution for Victims of SARS-related abuses and other matters, was admitted and marked as Exhibit PWO. 20. A faster flash drive with certificate of compliance were admitted and marked as Exhibit PWP and PWP1 respectively. 21. A disc titled Interview with Sahara Reporter with certificate of compliance was admitted and marked as Exhibit PWS. 22. The search warrant dated 28th day of October 2015 with search report was admitted and marked as Exhibit PWT. 23. A disc mass radio transmitter extra with certificate of compliance was admitted and marked as Exhibit PWU. 24. The statement of Benjamin Madugugu dated the 3rd day of November 2015 was admitted and marked as Exhibit PWD. 25. A SanDisk flash drive with its attachments and also with certificate of compliance was admitted and marked as Exhibit PWW. 26. Online printout of Vanguard newspaper and certificate of compliance was admitted and marked as Exhibit PWS. 27. A container containing a transmitter was admitted and marked as Exhibit PWY. 29. A certified true copy of report on request for professional assessment of radio transmitter dated 25th day of November 2015 was admitted and marked as Exhibit PWA2. 30. Certified to copy of Vanguard newspaper of 3rd day of July 2021 from National Library was admitted and marked as Exhibit PWP2. 31. The payment received with revenue collection receipt from National Library of Nigeria receipt number 19128 of 7th June 2025 was admitted and marked as Exhibit PWC2. 32. The report of assessment of the damage as a result of exercise was admitted and marked as Exhibit PWD2. 33. Death reports and certificates of security officers was admitted and marked Exhibit PWD2A. 34. Certificate of compliance was admitted as Exhibit PWD2B. PW1. The evidence of the witnesses. Mr. A.A.A. is an officer of the Department of State Service. His schedule of duties includes arrest, investigation, and taking of statements of suspects. According to him, the defendant is the leader of the indigenous people of Biafra group. He stated that his first contact with the defendant was on the 14th day of October 2015, when he was detailed by his commander in the Lagos office to go to Essential Airport Hotel to arrest the defendant. PW1 stated that he went with some other officers, with one of them named Bolaji Adeyemo. On arrival at the hotel, they introduced themselves and informed the hotel workers that they were there to arrest the defendant. PW1 even showed the receptionist the photograph of the defendant, but he was told that the defendant was not in the hotel. He then asked for the guest manifest, but the name of the defendant was not on the manifest. So PW1 reverted to his commander, who then ordered that they conduct room-to-room search. In the process, they enlisted the cooperation of the manager of the hotel, who availed them of the master key of the rooms. Shortly after, Bolaji called PW1, who was downstairs, with his director, informing him that he had found the defendant in room 303. On getting to the room, PW1 stated that he met a young lady who was later identified as Miriam Ibezimako. He introduced himself to the defendant and informed them of the purpose of their visit. Thereafter, they proceeded to arrest the defendant, who initially resisted arrest. PW1 further stated that during the encounter, Bolaji intervened to calm the situation after the defendant executed him, whereupon the defendant eventually agreed to follow them to the station. PW1 stated that the room looked like a broadcasting studio due to the broadcasting items mounted on the table, such as microphone, a tripod, and airport, transmitter, mixer, and cords. PW1 said they located the defendant at about 23 hours of the day. When they arrested him, they also arrested him with some of his baggage, which was listed in the sheet of papers which the defendant signed. He said the items recovered were about 70, and it took some time for him to complete the inventory. PW1 stated further that on the following day at about 9 a.m., he was instructed to take the statement of the defendant. So he took him to the interview room and recorded the statements from him, which was captured on video. PW1 stated that at the time he took the statement of the defendant, the allegation against him was that he was the founder and leader of an organization known as the Indigenous People of Biafra, IPOB. through which he allegedly agitated for the violent secession of Nigeria's southern eastern states, south-south states, and as well as two states from the north-central region, namely Benue and Kogi. Also, that he founded Radio Biafra, through which he broadcast his intentions, inciting the general public, particularly his followers and those who are sympathetic to his cause, to violence, to achieve the secession he was agitating for. PW1 then stated that he issued the defendant with his service statement form after administering the cautionary word onto the defendant, and then he proceeded to write down his statement. The defendant signed the statement and same was countersigned by me, PW1. PW1 stated further that the international passport of the defendant was recovered and brought to them the following day by the manager of the hotel, who found the passport on a bedside locker. Also, that the defendant used the name of Owanekei Ezebigo to book the hotel accommodation, and that was the name in the manifest. PW1 stated that during the interview of the defendant, he admitted to the allegation against him that he is indeed the founder and leader of indigenous people of Biafra group, and that he operated Radio Biafra, which is not registered by the Nigeria Broadcasting Commission or any other government agency. In addition, the radio station broadcast information across Nigeria and the world at large. Under cross-examination, PW1 stated that he was one of the officers who interviewed the defendant, and that during the interview, the defendant's lawyer was not present. PW1 said he took the statements of only the defendant, and that the items recovered from the defendant did not look offensive. Also, that they did not analyze the phone of the defendant as they thought it was immaterial at that time. He said he did not personally arrest and investigate any person who may have committed any crime on the instigation of the defendant. Furthermore, that he did not investigate the lady arrested with the defendant to see if he was aiding the defendant in terrorism activities. PW1 denied knowing if the defendant's name named any other person as a co-conspirator, or if any other person is standing trial on a related charge. PW1 said from his knowledge, the defendant had the support of persons like Simon Ekpa in his agitation for secession. He said the defendant incited others to destroy public properties. PW1 stated that even though there have been killings in other states such as Kaduna, Zamfara, as far as he could tell, those killings were not product of agitations for separation. He said he knows that IPOB was prescribed in 2017, but he does not have other details of the matter. PW1 stated that there are people who carried out the order of defendants, including sit-at-home order in which people have been killed for disobeying the directive. He stated that he is not aware that a charge against the defendant for inciting persons to kill military officer was struck out by the court. Under re-examination, PW1 stated that the agitation of the defendant in this case is for a call for separation from the country for the southeastern, south-south, and some north-central states. PW1, Mr. BBB, is an officer of the Department of State Service. He stated that the defendant is a member and leader of prescribed terrorist group called IPOB, which means the indigenous people of Biafra. PW2 also stated that he was assigned to take the statement of the defendant on the 17th day of July 2021, and that the purpose for the statement was for him to answer to the allegation contained in the letter sent to them by the Honorable Attorney General of the Federation. PW2 stated that the defendant is also the founder of Eastern Security Network, which is the armed wing of IPOB, and that he also established and operates Radio Biafra illegally, which was not registered with the Nigerian Broadcasting Commission, that the defendant told him all this during their interactions. PW2 further stated that during his interview, he was with his director and 4 other officers, as well as the defendant and 2 of his lawyers, namely Mr. Alo Ejimako and Abila Topchak. That the defendant admitted that he made broadcasts inciting people to burn, kill, and collect weapons from police officers wherever they see them. That the defendant also made written statements on the same day. He said the defendant admitted founding the Eastern Security Network, and that he admitted making broadcasts where he ordered his followers to ensure that whoever's mouth deceased had so ordered the attack, and they led to the death of many people, including destruction of properties. PW2 further stated that one of the unfortunate persons who lost his life includes Ahmed Gulak, the former senior special assistant to the President Goodluck Jonathan, who died on 30th May 2021, and also that the defendant made broadcast on the 20th day of October 2020 during the NSAS process, which led to the destruction of properties, including Lagos High Court building in Igoshere, as well as part of the Muritala Mohammed Airport. Further, that the defendant asked the employer to behead any military or police officers, and this led to the killing and beheading of a military couple in Odu, in Imo State. In addition, it was established that a retired judge, Honorable Justice Stanley Nnamdi, was also killed as a result of the defendant's broadcast. PW2 stated that the aim of the defendant was the creation of the Republic of Biafra by any means possible, including war. Under cross-examination, PW2 stated that the video statement of the defendant was a complete reflection of what transpired during the interview, even though the camera was focused on only the defendant and his counsel. He stated that he does not know if and how long the defendant was kept in solitary confinement prior to the statement being taken. He also said it was not part of what was related to him by his boss. PW2 explained that extradition is a process of bringing a person from another country to a country to start his trial. PW2 denied that an officer of DSS kidnapped the defendants in Kenya, since they are restricted to only Nigeria. He said Nigeria is a signatory to the United Nations Charter and as well as the African Charter, and that many countries got their independence through agitation for self-government. He said there is no country today known as Biafra, even though the Nigerian Civil War was fought on the agitation of people of Southeast attempting to form their own country. He said he does not know if the defendant's home was attacked or that 28 persons were killed. PW2 stated that he visited some of the places that were destroyed as a result of the broadcast of the defendant, such as police station in Ebonyi State. Also, that he is not aware of the status of Sarara reporters and whether it is registered. He said the defendant confirmed that he ordered seat at home in the southeast. PW2 confirmed that General T.Y. Danjuma, retired, has accused the Nigerian security forces of not being neutral. He said he is not aware that the Director General of DSS urging Nigerians to rise up and resist terrorism. He said he is aware that the Ensigns movement was never classified as terrorist organization. He said the defendant was and remained a member of IPOB before and after it was prescribed by the court. Under the examination, PW2 stated that Amotekun is not the same as Eastern Security Network, as Amotekun is recognized by law passed by the Houses of Assembly in the Southwest states, while Eastern Security Network is not registered, not recognized by any law, so it is an illegal association. PW3 is Mr. EEE is an operative of the State Security Service and have been with the agency for 27 years. According to him, the defendant is the leader and founder of indigenous According to him, the defendant is the leader and founder of indigenous people of Biafra, a proscribed terrorist organization, and also served as the director and broadcaster of Radio Biafra, which was used to incite the public. He stated that his first contact with the defendant was on the 24th day of October 2015 when he was instructed to interview the defendant to take a statement regarding the allegation about his activities in operating Radio Biafra and also the founder of IPOB. He stated that on the first day, he invited the defendant to the DSS interview room at the National Headquarters, where he and 3 other officers interviewed the defendant and also video recorded of the interview, which the defendant consented to. He said the defendant did not reduce his statement in writing until 23rd day of October 2021 due to complaint of his being tired and needing to rest on the 24th day of October. He said the written statements were then signed by the defendant when he finished writing. PW3 in his further testimony stated that during the interview of 24th day of October 2021, the defendant was confronted with video recording of interview with Sahara reporter. In that video, the defendant was arrested by officers of the DSS. He stated that allegations against the defendant include that he was agitating for the secession of Biafra and using Radio Biafra to incite members of IPOB against the Federal Republic of Nigeria. PW4 stated that on the 20th day of October 2015, through an intelligence, they discovered that the defendant smuggled a radio transmitter without the clearance sent to the Nigerian Customs Service, that it was hidden from view using household equipment and was contained in a container. PW4 stated that it was kept in the custody of one Benjamin Madugugu in Anambra. PW4 said he got to know all this when he was handed a video recording when the defendant was seen in the company of Madugugu inspecting the radio transmitter and taking ownership and declaring it as a game changer, which Radio Biafra will be broadcast through. Following an instruction from his superior, PW4 obtained a search warrant and on the 28th day of October 2025 proceeded to the village where Benjamin Madugugu was and retrieved the radio transmitter. PW4 stated that when they opened the container, they found only the transmitter in it and asked Benjamin what happened to the other items, and he said the defendant came to inspect the. It's one individual named Chimeze who took the other items away, leaving only the transmitter in the container. He said Benjamin Madugugu wrote a statement on the 3rd day of November 2015 at the DSS headquarters, and he confirmed the result of the search. Benjamin Nnamdi, when asked, did not produce any custom paper. Benjamin was initially arraigned along with the defendants until he jumped bail and the case was severed. He said, High Court has made life difficult in South-East due to the sit-at-home order of the defendant, as well as the violence unleashed by High Court. Further, the Eastern Armed Security Network, which is the armed wing of High Court, bears arms, engages in guerrilla warfare, where they attack security agencies such as the police and the Nigerian Army. They also ensure compliance with the sit-at-home order. PW4 stated that in a particular broadcast of 30th day of May 2021, the defendant issued threats that anyone who defies his order of sit-at-home by opening their shop should be killed and the shop burnt. PW4 explained that Ahmed Gulak, the former senior special assistant to the former president Goodluck Jonathan, was killed on the day declared to be a sit-at-home, that he tried to take another route to the airport in Owerri when he was shot by airport terrorists. PW4 said he was the fourth person at the scene and he found the lifeless body of Gulak on the road. He said that from the feedback they got from residents of Southeast, the sit-at-home order had depleted the economy and activities in Southeast and the people were living in apprehension for their safety. PW4 also said that he knew one Ukonzo, identified as one of the greatest commanders of Eastern Security Network, which real name is Kanu and he described Ukonzo as a ruthless commander who took direct orders from the defendants. PW4 further stated that Ukonzo was killed on the 24th day of April 2021 after masterminding attack in Olu, Imo State, during which he mobilized Eastern Security Network members and other adherents of IPOD to attack the correctional centers and facilitate the escape of numerous inmates who were in lawful custody. The autos containing the transmitter was recovered from the premises of one Benjamin Nnamdi, wherein the defendants had smuggled the radio transmitter into the country. The container also had some household items in it, which were later removed. Upon the matter being adjourned back to the court, PW4 confirmed that Benjamin Nnamdi indeed made a statement before the DSS during the statement taking, he had his lawyer, one Vincent Obeta, present with him. PW4 also stated that upon retrieving the radio transmitter, they brought the defendant and Benjamin Nnamdi together and confronted the defendant with the evidence. He stated that the defendant accepted ownership of the container and that the radio transmitter. He also exonerated Benjamin Nnamdi by stating that the items were only kept out. Benjamin Nnamdi to confirm and come and inspect the transmitter, which they duly came and wrote a report of the findings. The conclusion from the report as spread by PW4 is that the station known as Radio Biafra was not licensed by the Broadcasting Corporation of Nigeria. Neither does it have any permit to operate in Nigeria. That for an organization to bring in a radio transmitter, it must apply for permission from the regulator, who is in turn right to the security agency such as DSS and the National Security Advisor for clearance before the regulator issue a license to import the transmitter into Nigeria. That in this case, no such license permission was obtained by the defendant before importing this transmitter. PW4 referred to a newspaper story where the defendant had ordered an attack on prison in Imo. The defendant had ordered members of IPOB to kill security operatives. Also, that investigation revealed that the defendant having ordered members of IPOB to bury the Kozo in special way by using about 2,000 human heads. His men were only able to get 30 human heads. Efforts were made to arrest these IPOB members in Odu, in a village bordering Anambra Valley. They met some members of IPOB with human heads hanging from a wire mesh, and they also saw some of them eating human flesh, which they claimed was for spiritual fortification. They also saw as well where they dumped victims and the headed bodies into. PW4 stated that he was part of the operation which comprised the DSS and the Nigerian. He also stated that the defendant has never denied making those state broadcasts and was even proud of making them. PW4 also stated that record shows that between 170 and 200 security agents of the federal government were killed by IPOB and Eastern Security Network all over Nigeria. He knows some of these murdered agents, which includes his driver, one Shinemere Ereke, and their tactical leader who were killed in Umuma local government area of Imo State. PW4 stated that the defendant was in the habit of making inciting statements ordering his men to carry out attack on and burn down the place. He stated that on the 2021, the defendant had ordered a sit at home in southeast, but the late Ahmad Gulad was unfortunately caught in the storm as he was trying to catch flight out of Owerri Garden. PW4 said he was the first to get to the scene of that attack where he found the disease in the pool of his lot. He was informed by the divisional police officer in the area that the disease was in a taxi heading for the airport when the IPOB and Eastern Security Network armed combatants identified him as one of their checkpoints and opened fire on him. The driver of the taxi identified himself as an Igbo man, but the deceased, even though he claimed he was an Igbo man, could not speak the language, and having observed a prayer mark on his forehead, his attacker shot him. The body was later moved and conveyed in a plane to Abuja on the directive of the former secretary to the government of the Federation, Boss Mustafa. PW4 stated that between 2019 and 2022, he was in charge of security enforcement in Imo, and he witnessed firsthand the activities of the defendant and his men. PW4 stated that the defendant is the leader of indigenous people of Biafra, IPOB, as well as the founder and operator of Radio Biafra. He testified that the defendant used the said radio platform to incite members of the public to 8 persons of other ethnic nationalities. PW4 further stated that through his broadcast, the defendant directed members of IPOB to attack and kill security operatives and to destroy infrastructures and symbols associated with federal government as part of his agitation for the establishment of the Republic of Biafra under cross-examination. The investigation through the Tinkan port in Lagos. He said if he don't find out the date the Shamsa came into the country, her sail was smuggled into the country, and that it was not part of his schedule to find out this. That there are no records to show it came in through Lagos, save for the statement of the defendant that it came through the Lagos port. He also stated that IPOB was formed outside Nigeria and that Radio Biafra was operated outside Nigeria but broadcast within the territory of Nigeria as it was an online platform. He further stated that The defendant was arrested in Lagos with his broadcasting equipment. He said it is not the duty of the DSS to find out if the radio Biafra was registered in London. PW4 stated that he and one of the officers were sent to Ugulu to recover the transmitter, that they report do not kill Igbo person who violates the sit-at-home order. He admitted that the defendant said iPod will compensate the person which lorry of onions was hijacked, but he does not know if the promise was fulfilled. PW4 stated that it was the police who investigated the killing of Ahmed Gulak. He said during the sit-at-home, everywhere, including farm, are usually deserted, and it is dangerous for anyone to be outside. According to him, in July 2021, he was instructed to lead a team of officers of the police and the DSS and other investigators to travel around country to obtain and collect record of activities that occurred between 2020 and 2021 relating to the EndSARS movement. He stated that the assignments included obtaining records from head of security agencies in the states visited, particularly the states in the southeast and FCT, obtaining reports of deaths and death certificates of security personnel who died, as well as to Biafra or is a member of IPOB. He said he is aware that the police brutality was one of the causes of the EndSARS protest, and that the defendants urged people to take up arms against the government. PW5 said there is no part of the report stating the activities of IPOB or ESN. He also said all protocols relating to taking of photograph were duly observed. He said from pages 669 of the report, there are some visible dates on the photograph. PW1 stated that there is no portion of the document signed by himself as secretary of the Presidential Ad Hoc Committee of the committee that investigated the aftermath of the EndSARS protest, and the chairman of the committee. However, he stated that he certified the document and that the document was not certified after the proceedings of 12th day of June 2025. The defendant had filed a notice of preliminary objection dated and filed 16th October 2025, seeking for the following reliefs. 1. A declaration that the prosecution of defendant was that his extraordinary rendition has divested the trial court from continuing his trial. Thus, the instant trial is unlawful and in disobedience of the order of the appellate court. The defendant rely on the case of Okafor versus AG proceedings, that the provision under which he is charged to sustain these proceedings. He also submitted that his extraordinary he urged the court to quash the he also of jurisdiction as the subject matter of this charge is subject to uphold the preliminary objection. In written address filed on 30th day of October 2025, the defendants substantially repeated the submission in the notice of preliminary objection regarding the repeat law, extraordinary renditions, and denial of fair hearing. He therefore ordered the charge against him. And I quote, fair hearing within the meaning of section 36 of the Constitution of the Federal Republic of Nigeria 1999 means a trial or hearing conducted according to all legal rules formulated to ensure that justice is done to the parties. It requires the observance of two pillars of the rules of natural justice, namely, or the authorum parties and the modides in casa sua. Defendant, for instance, on the 29th day of April 2025, the defendant sought for an adjournment for cross-examination of PW1. Also, on the 2nd day of May 2025, the defendant counsel also sought for adjournment for continued cross-examination of PW1. Likewise, on the 18th day of May 2025, the defendant counsel applied for adjournment. In addition, on the 14th day of May 2025, defendant applied for an adjournment. Also, on the 21st day of May 2025, defendant applied for an adjournment as part of the options opened or as part of options after the close of the case for the prosecution. The defense opted for the option of filing no case submission, which this court duly had after adoption of written addresses. Ruling was delivered on the 26th day of September 2025, wherein the no case submission was overruled. The issue of extraordinary rendition, validity of the charge, all were incorporated in the no case submission. After going through the no case submission, the court overruled same, and the defendant was called upon to enter his defense. In the ruling delivered on the 26th day of September 2025, the court emphasized and laid importance to the issue of fair hearing as contained in Section 36 of the Constitution. The Department of State Security Service were not adequate to take care of his health. The court had quickly rushed back due to the importance of health of the defendant. The court ordered the President of Nigerian Medical Association to constitute a panel of experts to carry out tests on the defendant to ascertain his health status and whether it is fit to stand trial. The need to ascertain his fitness to stand trial was based on the antecedents of causing delay in this trial. The court was suspicious whether the issue of medical report dates at that stage was preemptive of the ruling and laying foundation for usual delay, which has been the trend since 2015. Based on this, the court added that the medical panel ascertained whether the defendant is fit to stand trial. It is actually a mystery to this court that a defendant who is standing trial would delay his own trial, while shouting that he is being denied his right to fair hearing. Usually, it is the prosecution that delays a trial as his life is not on the line. But in this case, the reverse was the case. The order of the court to ascertain his fitness was strategic to nip in the bud any attempt by him to further delay his trial. On the 16th day of October 2025, the court ruled on the medical report issued by the panel set up by the President of Nigeria before the court of the DSS dropping on the compensation of the defendant and his counsel. The court graciously asked the defendant and his counsel to use the courtroom for their pre-trial meeting since they felt more comfortable in the court. The development meant that the court had to clear the courtroom, and it meant that the court could not conduct hearing in the morning of 22nd day of October 2025 just to accommodate the defendant and his counsel. The court then adjourned the hearing for 23rd, 24th, 27th, 28th, and 29th and 30th October 2025 for the defendant to open and close his defense. On the 23rd of October 2025, the defendant representing defendants including Kanu SAN, Onyechipe SAN, Kodokoro SAN announced to the court that they wished to withdraw their appearance as defendant has indicated that he wanted to defend himself. The defendant had confirmed the development and informed the court that he wished to represent himself at the trial. Upon exercising his right to defend himself, the defendant came on the next date, and his excuse was that he was not given his case file by his departing counsel. This was no doubt another cause of a delay on his part. The following day, the defendant appeared for himself and began challenging the decision of the court, arguing that there was no charge against him and that the medical report certified him fit was alleged doctor. The court patiently explained to him that some of these issues he raising have been treated in no case submission and some of other issues could be raised during the final address. The court then who are experts in criminal litigation due to the seriousness of the charge against him. The court also offered to secure the service of counsel from the legal aids or a private legal practitioner willing to take the matter pro bono, which were all rejected by the defendant. The court continued to appeal to him and even on the death care. As a point, the defendant informed the court that he wanted to call about 28 persons as witnesses, some of which witness summons. The court graciously witness summons. However, the defendant abandoned these said witnesses and through the case file, and he found that there was no law providing for the offences he is being charged with, that he could not defend a charge not found on a law. By this time, the defendant has still not opened his defense. Neither was there any seriousness on his part to put his in effect. The court, in discharging his duty to do justice, calmly and patiently advised the defendant to be cautious of the path he tended to take, as it was tantamount to resting his case on the part of the prosecution, which means that he admits the fact, evidence against him, but believes that it is insufficient to secure conviction against him. This court has been extremely patient and lenient with the defendant. He is only entitled to be given the opportunity to defend himself as part of his right to fair hearing. Failure to use that opportunity granted by this court will be entirely his fault. He cannot complain thereafter of fair hearing. The right of a defendant to defend himself herself is a fundamental right, provided under Section 36 of the Constitution of the Federal Republic of Nigeria as amended. Such rights cannot be taken from a defendant except where a defendant to open his right. The court informing him that it was minded to extend the date if he opened the defense on the 7th of November 2027. The court on the 27th of October 2027 made an order that the defendant come on the next day to put his defense or file his final written address, or any written address filed by him will be deemed as his final written address in this suit. Pursuant to this order of the court, on the 27th October 2025, the defendant filed a motion on notice / comprehensive written address on notice on address on non-existence of a cognizable child and the unconstitutionality of continued of trial filed 30th of October 2025, and same will be deemed to be his final written address. That address is deemed as ordered by this court to be his final written address. The address as a comprehensive written address cannot be overemphasized. The word comprehensive, as used in that written address by the defendant, means, according to the online version of the Oxford Dictionary, is, and I quote, including, dealing with all, nearly all elements or aspects of something, unquote. The defendant in the motion on notice and comprehensive written address prayed for relief, including 4. The court to discharge him, which is a typical prayer in final written address in criminal matter. No doubt, the defendant clearly knew what he was doing by opting for final written address in form of motion / comprehensive written address in compliance with the order of this court made on the 27th day of October 2025. This would therefore be treated as the final written address of the defendant, and same have been treated and considered in the entirety. The defendant had also filed a notice of preliminary objection on the 16th day of October 2025. These two should be considered in the interest of justice, as the court having ordered that all preliminary objections will be determined in the judgment. Also, the preliminary objection filed on the 16th October 2025 is also considered thoroughly in this judgment. Another aspect of denial of fair hearing raised by the defendant is that he was misled into taking his plea in the charge. When the charge was read to was to be read to him, the court asked if he understood English. He responded that he did. When count 1 was read to him, he at first stated that he did not understand. The court ordered the registrar of the court to read the counts to him. He understood and took his plea. For the avoidance of doubt, I will reproduce part of the proceedings of 21st day of March 2025 when the plea of the defendant was taken. Registrar Nnamdi Kanu, do you understand and speak English language? Defendant, I do. Yes. Registrar, listening to the charge against you. Count 1. Registrar, after reading, do you understand count 1 I read to you? Defendant, I don't. Court, take it again. Count 1. Registrar, after it, do you understand count 1 I read to you? Defendant, I do. Yes. Registrar, are you guilty or not guilty? Defendant, not guilty. Count 2. Defendant, do you understand count 2 I read to you? Defendant, I do. Registrar asked, are you guilty or not? Defendant reacted, I'm not guilty. Count 3. Registrar read to him and asked him, defendant, do you understand count 3 I read to you? Defendant, I do. Registrar asked him, are you guilty or not? Defendant responded, I not guilty. Count 4. Registrar read and asked him, do you understand count 4 I read to you? Defendant responded, I do. Registrar asked him, are you guilty or not guilty? Defendant responded, not guilty. Count 5. Registrar read and asked him, do you understand count 5 I read to you? Defendant responded, I do. Registrar, are you guilty or not? Defendant responded, not guilty. Count 8, now count 6. Registrar read and defendant, do you understand count 6 I read to you? Defendant said, I do. Registrar, are you guilty or not? The defendant responded, not guilty. Count 15, original 15, now count 7. Registrar read and said, defendant, do you understand count 7 I read to you? Defendant responded, I do. Registrar asked him, are you guilty or not? Defendant responded, not guilty. The defendant clearly understands English language, being an educated man. On that day, he had his counsel, including senior advocates such as Kanu and SN, representing him on that day. The court complied with the procedure of taking the plea of the defendant in accordance with section 2712 and 3 of the Administration of Criminal Justice Act 2015, which provide us 1. The defendant to be tried on a charge or an information shall be brought before the court on federal unless the court says court otherwise to order, and the charge and information shall be read over and explained to him to the satisfaction of the court by the registrar or other officer of the court. B. Called upon to plead instantly unless where the person is entitled to service of the information he objects to the non-service and where the court finds that he has not been duly served. 3. The court shall record the fact that he is satisfied that the defendant understands the charge or information read over to him and explained to him in the language he understands, and shall record the plea of defendant to the charge or information as nearly as possible in words used by him. Looking at the above statutory provisions of Additional of Criminal Justice Act, the procedure adopted by this court, the defendant cannot turn round to claim he was misled to take plea after the prosecution has closed his case. It is nothing but the usual habitual flaw of the defendant to cause delay and make the matter to start with de novo. This court will not allow matter to be on the court list ad infinitum. On the issue of denial of adequate facilities, the defendant claimed that he was not allowed to consult with his legal representation in confidence at DSS, as the DSS officers were dropping on their conversations. The defendant is facing criminal trial and is entitled to the right to adequate time and facility in preparation for his defense. He enjoys the constitutional right to fair hearing, and in consequence to this right, has the right to adequate facilities. He must be afforded every opportunity to defend himself once he becomes aware that he has a charge hanging upon his neck for an infraction of the law and makes a request either orally or in writing for any facilities to prepare his defense. The court must accede to his request and the prosecution has to comply. The facilities that must be afforded the accused person are the resources, anything which will aid the accused person in preparation of his defense to the crime for which he is charged. This, no doubt, includes the statements of the witnesses interviewed by the police in the course of the investigation, which might have absolved the accused of any blame or which may assist the accused to support such favorable witness that the prosecution counsel may not want to put forward to testify on oath. See case of Nweke and the state citation supply. The defendant did not provide any credible evidence as to this allegation of airdropping. The court, however, in order to do justice to him and suspecting that he was looking for another way to delay this trial, allowed him to consult with his lawyer on the 22nd day of October 2025 in the courtroom. Thus, the court had to vacate the courtroom for him for his lawyer to use. Despite this magnanimity by the court, the defendant did not make use of this opportunity. On the following day, the counsel withdrew his appearance. The defendant decided to defend himself, making the opportunity given to him to use the courtroom to be useless and of no purpose. Despite the fact that he is not a legal practitioner, he began using some of his counsel who he had earlier disengaged to act as legal consultants to him. The court even kindly ordered the DSS to allow these consultants have free access to him. This is in compliance with Section 36 of the Constitution within the requesting country jurisdiction. Extradition process is usually spelled out in bilateral or multilateral extradition treaties or agreements. Extradition becomes necessary when a criminal polity flees from one country to another to avoid facing trial or punishment. Persons who may be extradited include those who have been tried and convicted but escape custody by fleeing the country and thus convicted in absentia. A trial in which the accused person is not physically present. Extradition is distinguished from other modes of forceful removing undesirable person from the country, such as exile, expulsion, deportation. Extradition procedure are usually determined by the terms of the treaties between individual countries or by multilateral agreements between group of countries, such as the Commonwealth countries or the countries of the European Union. The receiving government then refer to its law. Its treaties specify obligations to the requesting nation and decide whether or not to extradite the persons named in the warrant. Treaties signed in recent decades versus Illinois. 119 U.S. 436 1886, and the case of Freedly versus Collins 342 U.S. 519 1952, where a messenger forcefully kidnapped the defendant from Peru and brought him back to the United States, even though he had been sent to Peru with a valid warrant and instructions to obtain the defendant with the cooperation of the local authority, addressing Kelb's due process challenge. The Supreme Court of the United States held that, and I quote, "Such forceful adoption is not sufficient reason why the party should not answer when brought within the jurisdiction of the court, which has a right to try him for such an offence, and presents no valid objection to his trial in such case." In Freedly v. Collins 342 U.S. 519 1952, it was a case where the defendant was tried and convicted in the state of Michigan. Evidence regarding the extraordinary rendition. The court will consider the effect of the extraordinary rendition on the validity of the trial of the defendant. The defendant, in his written address, has argued strenuously that the way he was brought back from Kenya was illegal, and thus initiates his trial before this court. He relied heavily on the decision of the Court of Appeal in Federal Republic of Nigeria versus Kanu, in appeal number CA/ABA/CR/C25/2022, delivered on the 13th day of October 2022 on the issue. The court held, and I quote, "The consequence of this session, I hold that the respondent is prohibited from being detained, tried, or otherwise dealt with in Nigeria for or in respect of any offence allegedly committed by him before his extraordinary rendition to Nigeria. The lower court thus has no jurisdiction. I further hope to try the appellant on counts 1, 2, 3, 4, 5, 8, and 15, which were retained by it, being charges allegedly committed by the appellant prior to his extraordinary rendition. In addition, by the forceful adoption and extraordinary rendition of the appellant from Kenya to the country, these laws and rules, conventions, etc., do not take away the pride or rob the jurisdiction of the trial court to adjudicate over or try the offences the respondent was arraigned for on the basis of procedure used or employed to bring or produce in before the trial court for continuation of the trial. I must emphasize that even this court, as the apex court in Nigeria, cannot, by pronouncement, take away the pride or even factor the jurisdiction or conferred or vested on the court of record by the constitution or a statute, let alone pronouncement by foreign courts on such foreign international convention, treaties, and agreements, or even if domesticated. In this result, the issue is resolved in favor of the appellant to the effect that the trial court is appropriately vested or conferred with the requisite jurisdiction to adjudicate over and try the process. But the reality in Nigeria's particular situation is that no allegation of commission of a crime will be tried if the court declines jurisdiction to try a criminal case or invalidate it because of the violation of fundamental rights of the accused person or other unlawful actions of the prosecution that occur in the process of investigating the criminal complaint against him, or in the process of initiating the criminal case arising from such complaints, or in process of bringing him to court, or in dealing with him while he is standing trial. This is because criminal law enforcement officers routinely engage in unlawful actions and raising violation of fundamental rights of suspects in the investigation and prosecution of virtually all criminal matters. The effect of the holding of the Supreme Court is that, notwithstanding the legality or otherwise of how the defendant was brought back from Kenya, it does not invalidate his trial. The court will control the line set by the Supreme Court as the apex court of the land. His decisions are final, override all other courts, including the Court of Appeal, which defendant is based on the repeat law. The general rule regarding the charge is that it must be premised on written law. See section 36, sub 12 of the Constitution of the Federal Republic of Nigeria, and it provides, and I quote, subject as otherwise provided by this Constitution, the person shall not be convicted of any criminal offence unless that offence is defined, and the penalty therefore is prescribed in a written law. And in this subsection, a written law refers to an act of National Assembly or a law of state, any subsidiary legislations, instrument under the provision of the law, unquote. The above provisions were enforced 2 years before the defendant's arrest in 2015, meaning this court had requisite jurisdiction to try him then. His initial trial, therefore, was based on an existing and valid legal foundation as at then. This instance means that at the time he was charged, the Terrorism Prevention Amendment Act 2013 was the extant law of the land. It would have been different if the defendant's offences were allegedly committed after the Terrorism Prevention Act 2022 have been enacted. The Terrorism Prevention Amendment Act 2022 comes into effect on 12th day of May 2022, which is a later date compared to when the alleged offences were committed. The Supreme Court in Federal Republic of Nigeria versus Kanu Supra, this is the year 2004, and it's also called or shown to be chapter C38 in volume 4 of the publication. It is apparent, therefore, that the Criminal Code Act is not cap 45 or cap C45 in volume 4 of the Laws of the Federation of Nigeria as indicated in count 15 of the charge against the respondent. Rather, Criminal Code Act is chapter 38 or chapter C38 in the Laws of the Federation of Nigeria 2004. However, the same Laws of the Federation of Nigeria 2004, chapter 45 or cap 40 C45